excited to introduce to you our very last panel of the day, in which we will look ahead and look at the 2012 term, the cert petitions that have been granted, as well as cert petitions to watch. And moderating this panel will be Chicago Kent's own Professor Carolyn Shapiro. Professor Shapiro is an associate professor here and director of the Institute on the Supreme Court of the United States. She earned her BA from the University of Chicago, her master's from the University of Chicago Graduate School of Public Policy, and her JD from the University of Chicago Law School. Among her many accomplishments following law school, she clerked for Chief Judge Posner of the Seventh Circuit and then for Justice Breyer of the U.S. Supreme Court. During her career, Professor Shapiro has worked on several U.S. Supreme Court cases at both the cert and merit stages, and so we are fortunate to be in her capable hands.
Thank you so much. Well, I'm going to start by introducing our panel, and I do have to add the disclaimer that I may have some experience with the Supreme Court, but I am probably the person in the room knowing the least about IP. So I will be sort of the every person asking our panelists to explain things, so that people whose expertise might not reach those particular areas will be on top of things. So to my immediate left is James Dabney, a partner with Fried Frank, and also an adjunct professor at Cornell. James is, among other things, counsel for the petitioner in the case of Allready LLC versus Nike, which he'll be talking about in a couple minutes. On the other side of James is Matthew McGill, partner at Gibson Dunn, and counsel for the respondent in the case of Kirtsaeng versus John Wiley, which is a case that presents a question about copyright law that actually was argued in the same question was presented in an earlier case in the Supreme Court in 2010, a case called Costco versus Omega. In that case, the court affirmed by an equally divided vote. And the person one of the people who argued that case on the same side of the issue is here on our panel, Aaron Panner. So he may offer a few words of wisdom based on his experience in that case and some of his other Supreme Court experience. And then between Matthew and Aaron is on the end, is Tom Goldstein. Tom is the founder of SCOTUS blog, which if you are not a regular reader, you should be. It's a wonderful resource for all kinds of information about what's happening in the Supreme Court. And he's expert in many things, and he's filed an amicus brief also in the copyright case I just mentioned. But he's also going to be do our roundup of petitions to watch, but our other panelists will weigh in on those as well. So we will try to have time for Q&A as we get towards the end. So James, could you talk to us a little bit about Allready versus Nike and the basic factual background and the question presented as it's going up to the court?
Certainly, and let me also preface my remarks that they are my remarks and not those of any client or party to the case in the Supreme Court. The Allready case is the third case in 20 years in which the Supreme Court of the United States has taken up the question, when may a federal court review the validity of a claim of right to exclude competition under a patent, or in this case, a registered trademark, in both instances under agency actions of the PTO. The first of these cases was a case called Morton versus Cardinal Chemical, which was decided in 1993, in which the court disapproved of a doctrine under which the Federal Circuit had held that if a claim for infringement is rejected, the judgment of non-infringement renders moot and beyond the Article III jurisdiction of a court to decide whether or not the asserted intellectual property right was invalid. The next case was decided in 2007 in a case called MedImmune. MedImmune had to do with a Federal Circuit doctrine which had held that under Article 3 of the Constitution, a federal court could not hear a claim seeking a judgment of invalidity unless the person seeking that relief at the time he filed suit was himself, herself, or itself in reasonable apprehension of suit for infringement. And the Supreme Court in Metamune disapproved of that doctrine and held that there are other circumstances in which a federal court may have jurisdiction to review the lawfulness of a claim of intellectual property right. Allready is in this same line of authority. Allready is a case in which the holder of a registered trademark filed suit for infringement, had filed against it a counterclaim for a judgment declaring invalid the claimed trademark. And after the suit had been underway for 9 months, the plaintiff changed its mind and delivered a covenant not to sue and consented to the entry of judgment against itself on the merits, and took the position that by conceding defeat in the case and by waiving and abandoning all of its claims against the defendant, those actions had rendered moot any controversy over which the federal court would have jurisdiction to hear the compulsory counterclaim of invalidity. And the Supreme Court granted cert in June on the question of whether a federal court is divested of jurisdiction over a pending counterclaim for a judgment of invalidity when the original plaintiff in the case delivers a covenant not to assert its rights against any existing products of the defendant or any colorable imitations of the defendant's accused products in the case. And the case is going to be argued on November the 7th. This is a case that once again pits those who favor greater federal court authority to review the handiwork of the Patent and Trademark Office versus those who would seek to diminish federal court authority to review the handiwork of the Patent and Trademark Office. The Solicitor General has filed a brief that has supported a somewhat broader view of federal court authority than the lower courts had recognized in this case, but not as broad as the petitioner is saying should be the case. So that's the Allready case in a nutshell.
So it's not, there are implications of the Allready case, it seems to me, go far beyond trademark law. The question is, writ larger, can a party moot out another party's claim? Under what circumstances?
That's absolutely the case. The reason I think we have had 3 Supreme Court cases on the meaning of cases, capital C cases, in the IP field, is that in the Federal Circuit era, there grew up in parallel 2 completely different standards of when a case is a case. If the question is, can I walk on the parking lot to picket the employer engaged in an unfair labor practice, I say, against a law that would supposedly exclude me from doing it, one set of legal standards was applied. If the question was, can I make this product, despite the existence of a government-issued document which purports to give my competitor a right to exclude me from doing so, a completely different set of standards had been grown up in the Federal Circuit era. And despite the fact that in both Cardinal Chemical and in Metamune, the Supreme Court seemingly disapproved of a specialized IP-specific rule of federal court jurisdiction, the Allready case is actually a vestige of the doctrine that was disapproved in Metamune. Within the patent community, the rule at issue in Allready is known as the Super SAC rule, named after a 1995 decision in which the Federal Circuit held that a patent owner who delivers a covenant not to sue can thereby render moot a counterclaim for invalidity. What doesn't seem to be recognized and is still not widely recognized apparently is that the foundation of that rule was shot away in Metamune. The foundation of that rule was, well, unless there's reasonable apprehension of suit, there can be no Article III jurisdiction. The delivery of the covenant eliminates apprehension of suit, therefore there can be no Article III jurisdiction. Well, if you get rid of the reasonable apprehension of suit condition of Article III jurisdiction, suddenly the super sac rule is without any foundation at all.
So then the question becomes, is there sufficient injury in fact? And in the petitioner in your case is arguing, yes, you do have injury in fact.
Yes, and this is where the difference between the petitioner and the government comes into play, because what constitutes injury that an Article III court may properly redress is not a self-evident question. And the government is resisting the idea that the mere unlawful granting of a patent, the mere unlawful registration of trademark ineligible subject matter can never constitute injury, even when the government's allegedly unlawful action purports to regulate the existing and ongoing business of a competitor, of the applicant or registrant. The government is insisting that jurisdiction in such cases revolves some kind of threatened enforcement action, and this is really a kind of a watered-down version of the reasonable apprehension of suit test. The petitioner in Allready is saying that when the government sees fit to grant a patent which regulates a competitor's business, when the government sees fit to register a claim of trademark ownership that purports to disadvantage procedurally and substantively the business activities of a competitor and to increase the risk of a competitor engaging in business, that is a form of injury that compares very favorably with many forms of injury that have been held cognizable in federal courts in the past. So yes, we take a somewhat more expansive view of what can constitute injury in fact than the government does.
And I do want to point out that there's another case on the Supreme Court's docket this year that also addresses the question of when a party can moot out another party's claim. It's not in the IP context. The case is called Genesis Healthcare Corporation v. Simchick, and in that case, the defendant made an offer of judgment to the plaintiff that would have satisfied the money parts of her damages. And the question is, did that offer of judgment have the effect of mooting out her underlying claim? Well, thank you. I'm going to move on. We will, as I said before, we will have time for questions and Q&A from the audience. But first, Matt, if you could talk to us a little bit about the issue in Kirtsaeng versus John Wiley.
Sure. And thanks to the organizers for having me here today, and thanks for you all for hanging in to the bitter end. Kirtsaeng versus Wiley is a case about textbooks. John Wiley and Sons is a publisher of textbooks, and Mr. Kirtsaeng for a while was a kind of an entrepreneur of sorts who imported textbooks from Thailand, where he bought them at low prices and then resold them in the United States, where he could sell them for higher prices. The case revolves around a statutory provision, Section 109 of the Copyright Act, that codifies something known as the first sale doctrine. The first sale doctrine, the current codification states as follows: notwithstanding the provisions, blah, blah, the owner of a particular copy lawfully made under this title, or any person authorized by such owner, is entitled, without the authority of the copyright owner, to sell or otherwise dispose of the possession of that copy. So that means how this affects you in your daily life. If you buy a textbook at the bookstore, you have lawfully purchased a book, you can sell it to somebody else. You could rent it, you can lend it out, you can hang it on a wall. You can do all of these things with the textbook you purchased here in Chicago. The question in this case is whether that same rule applies if the textbook is purchased and made not in the United States, but instead is made in other countries. And so the case turns on the meaning of the statutory phrase, lawfully made under this title. So it's really less of a copyright is the subject matter, but the case really is a straightforward statutory interpretation case. What does the statutory phrase lawfully made under this title means? And the court had addressed this question somewhat in a case called Quality King in the 90s. And in that case, the court at least suggested that a book that was made in the United States, that was manufactured in the United States, would be made under this title, meaning made under or pursuant to the Copyright Act. But it suggested that a book made outside of the United States would not be made under this title, and therefore this Section 109 would not apply in those circumstances. So the case, this issue arose next in a case called Costco versus Omega that Aaron argued. That was 2 terms ago in 2010. And the court divided 4-4 on that. Justice Kagan was recused because Justice Kagan, as Solicitor General, had filed a brief in support of Aaron's client, Omega, in that case. So she was recused, and the court divided 4-4. So now we have the issue coming up again. We do have 9 justices. So we expect to get at least, it won't be affirmed by an equally divided court.
Now, do you have a sense of who the 4 are on each side?
It's very hard to say because, of course, the court doesn't, when the court announces an affirmance by an equally divided court, it doesn't tell you how they divided. And it's not completely clear from the transcript where the justices came down on this question. So I've got my hints, but they'd be nothing more than kind of guesses. Aaron might have a better idea.
Aaron, do you want to offer him some advice?
Well, I was respondent in Costco, so don't screw it up. So,
You got him 4 votes. He just has to get 1.
well, but what I mean, he's probably going to win 6-3 or 7-2.
It often it's an odd thing. It often happens in the Supreme Court. It will evenly divide 4-4. Then they'll come along to the same question later, and there'll be 6-3 or 7-2. Wait a second, you were just 4-4.
Yeah,
Is that it?
and I'll feel fine about that if we win. I think it was very hard to tell, and this is a tricky case. One piece of this that is important to emphasize, and what makes this kind of a puzzle, is that there's actually a separate statutory provision, which Matt didn't get to in describing the case, which specifically deals with importation and specifically makes it illegal to import copies acquired abroad. And that acquired, I don't remember what the phrase is after acquired, but that word acquired is important. It says, if a copy is acquired abroad, you cannot import it without the authority of the owner of copyright. That's actually Section 602A1 of the Act. And one of the things that's lurking in this case is that's a pretty strange, if the first sale doctrine applies to copies that are made and sold abroad, 602A1 all of a sudden becomes sort of a vanishing provision, because there's no, you can come up with clever instances in which it would still apply, but basically it doesn't apply anymore. It doesn't have any real function. And so I think that the respondents have that on their side here. The real puzzle in this case is not so much the application and circumstances like the case, the Wiley, Kirtsaeng v. Wiley case, or the Costco v. Omega case, where the statute is being applied in a circumstance where the importation was unauthorized and the sale was unauthorized. The real puzzle that comes up, and the reason why I think this case ends up being very tricky, is a circumstance where if you say that lawfully made under this title means lawfully made in the United States, it suggests that the first sale doctrine, at least the statutory version of the first sale doctrine, does not apply at all to copies that are made overseas. So suppose you have a book and it's printed in Mexico and it's imported with the absolute authority of the author, and it is then sold in Barnes & Noble. What the folks who are attacking what the petitioner is saying is, under the Second Circuit's reading, first sale doctrine doesn't apply, and you could have, you could impose post-sale restrictions on the resale of lawfully, copies that were lawfully made overseas and that were lawfully imported, and that's just insane. And so it just can't be that lawfully made under this title means lawfully made in the United States. And so what's interesting about it is that where they spend all their time is on a case that has never been brought and presumably never would be brought, which is a case where somebody tries to enforce a copyright after a lawful first sale, an authorized first sale in the United States. But in terms of whose votes Matt can count on, there's really only one vote that he and I both know that he won't get, and otherwise I'll leave it alone.
I filed a brief in favor of both of them, so I hope they win. But on behalf of the ABA, I will say, just to continue to give the other side its due, one other argument that they make is why. Why would Congress kind of specially privilege this overseas manufacturing? Why would you want to adopt a regime that, if you look at it kind of from an economic sense, would cause people to be more likely to publish works overseas to give themselves greater for sale rights than have them published in the United States? And so I think that's a second theme of theirs. I do think that the textual arguments are certainly stronger on these guys' side.
And then one other point, just to follow up on Tom's point, which is very true, and it was actually a question that I got very pointedly from Justice Ginsburg at argument in Costco, was why would Congress do this and seemingly provide this incentive to manufacture overseas? The part of the answer to that, I think, in truth, is that Quality King is not necessarily correctly decided. And what happened in Quality King is it's actually a pretty wooden decision, which said, well, first sale doctrine applies, 602A1, therefore is subject to the first sale doctrine. These copies were lawfully made in the US, and therefore they can be imported, without necessarily thinking sort of functionally about what is it that 602A1 is intended to do. And obviously what it's intended to do is protect not the right to reproduce the copies in the US, but to protect the right to distribute the copies in the US. So if the copyright owner exercises only the right to reproduce the copy in the US, exports it without a sale, and then sells it overseas, there's a pretty good argument that on a proper reading of 109A, that the right that the right that's of interest, in other words, it's really an exhaustion doctrine, and the right that's relevant, which is the distribution right, hasn't been exhausted in the case of a copy that's made in the U.S. and exported without sale. But that's
very hard to tell the Supreme Court. You see, we're right because your last decision was breathtakingly wrong.
Right, which is why no one would say that, and why that's all water that's very much under the bridge. But
Well, there's another, your point that this is an exhaustion doctrine, I think, is very important, because this exact same issue has been a very hot subject of litigation in the patent field in recent years. And unlike the Copyright Act, the Patent Act has no statutory provision that's a counterpart to 109 of the first sale doctrine. To the extent that the exploitation of a claimed subject matter at a patent is deemed in law to exhaust the rights of the patent owner as to that subject matter, is all a product of of case law decision-making that has resulted in some surprising results recently. In the Quanta case, for example, the Federal Circuit has held that the first sale doctrine does not apply for overseas sales of subject matter protected by patents. And it's easy to understand at least some of the reasoning why that might be so. If it were not so, it would lead to all of these. You wouldn't be allowed to sell therapies at very low prices in Africa, for example, if they could then just be re-imported back into the United States. For example, it's a reason why you might not want to hold woodenly that the exploitation of a patent outside the United States results in exhaustion of the United States patent rights. And I'm sure that the litigants will have highly developed arguments about what is meant unlawfully under this title, but from my point of view, there's a much simpler way. I was telling this to Matt before we came in, that is that in order for a right to be exhausted, it has to have been exploited. And it doesn't seem to me that in any of these cases that the U.S. rights have been exploited, and therefore they couldn't have been exhausted. So we can talk a lot about the textualism, but I think that those who are favoring the respondent side in this case have the much better of the argument, I think.
Well, what you're saying is very consistent with Aaron's point about distribution.
Yes.
So,
Yes.
What the case, I mean, as Aaron said, critical to the case is how this first sale doctrine codified in Section 109 fits together with Section 602A1, which makes unauthorized importation of a copyrighted work an act of infringement. So how do those two provisions that were enacted at the same time in 1976, how do those two provisions fit together? And what we know is that in 1976, when Congress passed Section 602A1, it was trying to deal with John Wiley's problem, not John Wiley specifically, but publishers' problems about segmenting markets. Publishers wanted the ability to sell at different prices in different markets. And if importation could happen freely, then that ability to segment markets would be eliminated. And that ability to segment markets, publishers maintained, was quite important because it was the profits that they made in the United States that allowed them to publish at lower prices in developing countries. And if you don't allow us to segment markets, where the answer will be not importation freely from India or Thailand, it will be the elimination of publication in India or Thailand of our books. So that was the argument that was made before Congress. That was what prevailed. So the question is, how do you try to have a first sale doctrine that accommodates that result that Congress evidently intended? And the real trouble that the other side in this case has is that their argument is that they get to do precisely what Congress tried to stop. They get to import from Thailand cheap books and sell them in the United States at higher prices. That's exactly the result that Congress tried to put an end to. And that's what they want to accomplish.
I want to just do a shout out to my legislation students who I see out in the audience and point out how much of what we've just been talking about up here we could have talked about in class last spring. But now I want to move on to talk about the long list of cert petitions. Very interesting and diverse group of cert petitions that they're actually listed, or at least some of them are listed on the last 2 pages of your handouts. And Tom Goldstein is going to give us a quick rundown, and then other people may weigh in or even add to this discussion. So, Tom.
Terrific. Thanks so much. I should add the caveat that I am, as was mentioned, on the other side of the Allready versus Nike case. Nike has a strong policy about not commenting on pending litigation, so I would not assume that I agreed with Jim's description of the case. I'm going to describe, I think, 5 or 6 pending cert petitions in the IP area that I think have a reasonable chance of being granted this term. If more than a couple were granted, I'd be surprised, but they're all significant, and they, even if not granted now, they represent some of the significant questions percolating up in the direction of the Supreme Court generally from the Federal Circuit. The first case is J Reynolds against Star Scientific. This is a definiteness case. This is the complaint that the Federal Circuit's interpretation of the definiteness doctrine means if a bunch of lawyers got in a room, could they eventually figure out maybe what it meant when you had the words in the patent, rather than J Reynolds says a rule of definiteness for the patent that requires that the people who are in the marketplace will read the patent and know what it is that's being invented and what it is that they're not allowed to do. The idea, the complaint being that there's too much post hoc determination of what's been patented. This is a patent on a tobacco curing invention that talks about a climate-controlled facility. And J Reynolds says, you know, that could mean a lot of different things. We don't know, we didn't know sufficiently ahead of time what was protected here so that we would know not to practice this art and that we would be infringing. And that is a significant and recurring question in the Federal Circuit, and there's a lot of interest in this case. The next case is called Byrne, B-Y-R-N-E, versus Wood-Herson. This is a follow-up to the Supreme Court's Grable decision. The court is often, as Nike versus Allready illustrates, interested in jurisdictional questions. This is the relationship between federal arising under jurisdiction and legal malpractice claims involving patent registration and patent prosecution, and when it is that a patent is sufficiently involved in a case that a malpractice suit belongs in federal court rather than in state court, just a successor to Grable. The third case is called Retractable Technologies versus Becton Dickinson. This is the recurring question of when it is that you can resort to the patent specification to figure out what the patent means. The patent here claims a body, and the Federal Circuit said that it could look to the specification to determine that the patent term body means a 2-piece body versus a 1-piece body. And you know, depending on what judges you have on the Federal Circuit, you are not surprisingly going to have different levels of solicitude for the specification versus the claim terms. It's not unlike the Supreme Court, where you have justices who are more plain meaning folks and more legislative history folks. And this is an attempt to draw the Supreme Court into that debate. There have been a lot of cert petitions like that before. They all seem a little bit fact-bound because the patentee is always able to claim something or identify something in the claim terms, but it's an important and recurring question. The fourth case is GSK versus Clausen. This is the third case that the Supreme Court, or there have been 2 cases about this statute. The Supreme Court's being asked to decide a third one. This is Section 271E1. These are cases that involve gene patents. And when it is that the patent right has been exhausted with a gene patent, because gene patents are self-replicating. So what happens is Monsanto makes a herbicide and then made acquired a patent on a change to the genes of soybeans that would resist the herbicide, so that you use this patented gene formulation of a soybean, and then you can use the herbicide, and the herbicide will kill everything else except your soybeans. Well, the first sale problem for Monsanto is once I sell you your first set of soybeans, you can grow more of the patented item, and do you thereby, has Monsanto exhausted its rights? And Monsanto tries to deal with this problem by contract. These are people who, the petitioners, defendants in the case who lost below, are people who purchased from Monsanto, followed the license, but acquired more of the soybeans from someone else. And there is a lot of confusion about what to do with first sale rights when the product is self-replicating in this way. And so I apologize. What I've done is I've given you the wrong name of the case. That's Bauman versus Monsanto. That's the gene replicating case. GSK versus Clausen, I apologize, is the 271E1 case. And the question there is a provision of the patent laws that says that if you engage in what would otherwise be an infringing act when you are working on something that will be submitted to the government, and it generally happens with the FDA, you are immune from infringement liability. And the Federal Circuit, the petitioner says, has limited that statute only to times when you are trying to prepare, you're getting pre-market approval for a generic drug. And so it's the GSK versus Clausen case is about that exemption from infringement liability. The sixth of the 7 cases is Libertarian Party versus Washington State Grange. This is the Libertarians Are Very Clever People case. They lost an earlier case that was a challenge to Washington State's primary system, in which the person who goes onto the ballot identifies what their favored party is. And the Libertarians believe that the only person who should be able to put Libertarian down is the official Libertarian candidate, not somebody who just wants to say, my favorite party is Libertarian. And the last go-round, the Supreme Court rejected a facial challenge to this statute. This go-round, the Libertarians claim trademark infringement, that we are, we're the Libertarians, that we have that, you can't dilute and have a false designation of yourself as a Libertarian. That argument has no hope. I just thought it was extremely clever. The seventh case is actually one case right now, and there's a good chance it'll be 2 cases. They involve pharmaceutical reverse payments. The first one is Merck. It's known in the lower courts as In re Cader. These cases are generally known by the drug name. So the Third Circuit is a case called Cader. The 11th Circuit case is called Androgel. This has been a recurring controversy over the following scenario. Brand name invests in its patent, gets FDA approval, goes into the market. Under the so-called Hatch-Waxman scheme, a generic is encouraged to come along and challenge the patent and gets certain rights if it successfully challenges the patent. And in the litigation, once it says it's going to go into the market, then the brand sues the generic for infringement. And what happens sometimes in these cases is that they get close in the case, and the brand perceives a risk that it's going to lose its very important patent, and it not only settles the litigation by arranging for an entry date for the generic, but it will also give the generic money, say $50 million. To not enter the market. The plaintiffs in these cases allege that this is in what are known as reverse payments or exclusion payments. And most of the courts of appeals that have confronted this question have said that those sorts of arrangements are immune from antitrust scrutiny because it's in the nature of a patent that you get to exclude competitors from the market. And unless it was a sham patent or the agreement goes beyond the scope of the patent, that's a perfectly legitimate thing to do. The Third Circuit has come out the other way on that question and said that antitrust scrutiny does apply. The Supreme Court has had a few cert petitions about this in the pre-circuit split era, but now that there's a conflict, there are multiple pending cert petitions about this. I represent the plaintiffs in the cases from the Third Circuit, but that's a case certainly that has a shot at Supreme Court review.
And there's one more case, James. Did you want to talk about another case involving antitrust and patent?
Yes, there's a case that I'm involved in that involves the following scenario, which is a variant of the one that is involved in the reverse payments case. And that is the scenario in which an inventor makes an invention. In this particular instance, a formulation that would make generic entry possible with an incumbent branded, develops it under terms in which the remuneration for the inventive activity is a percentage share of the profits that would be generated by the sale of the generic rival product. And in that scenario, the branded pays $70 million a year to the would-be manufacturer and marketer of the generic product. And the issue in that case is the loss of the inventor's putative royalty share the kind of injury that federal antitrust law exists to redress when it happens. So this is a case in which, because the plaintiff is not a buyer of the drug, and it is a developer of drug formulations, not a manufacturer and marketer competing in the marketplace, does it somehow fall through the cracks? And since it's neither a competitor nor a consumer, its injury is simply not injury that federal antitrust law cares anything about redressing. There is, we believe, a very, very clear and long-standing split in the circuits over what's known in antitrust circles as the consumer competitor rule, under which our client's case was thrown out. And the Supreme Court is scheduled to make a ruling on whether to grant cert in that case at the beginning of the term. So that's a case called Sigma Pharm against Mutual Pharmaceutical, and the underlying alleged violation of the Sherman Act is the same type of agreement that is the subject of the K-Dur litigation, but is a much more vulnerable type of agreement because most of the cases that Tom was talking about are ones in which litigation is commenced, litigation is settled on terms in which the supposedly aggrieved patent owner settles on the basis of it paying reparations to the alleged wrongdoer or putative infringer. And that's what raises eyebrows as to, well, maybe something else is going on than legitimate settlements of litigation when in substance what it amounts to is a horizontal division of the market with the incumbent agreeing to share the loot with the putative infringer. But those cases have gone off to date on the basis that, well, there's a policy in favor of settlement of litigation, and therefore we don't want to make it too hard to settle patent litigation, number one. And number two, the antitrust litigators and the courts hearing these cases seem to be unwilling to go behind the presumptive validity of the patent to inquire whether the particular patent offered as a complete defense to what would otherwise be a per se illegal horizontal market division agreement, in fact, has any validity. And it's ironic that in an antitrust era originated right here in Chicago by the likes of your judge, that we're supposed to focus on objective economic factors and the actual economic realities, and we're not supposed to focus on the subjective beliefs and motivations of the parties. In this context, everything depends on the uninformed, subjective, supposed good faith on the part of the settling parties, that regardless of whether the patent is as phony as a $3 bill, it is nevertheless the subjective views of the parties that are controlling on whether they have absolute immunity to federal antitrust liability. So,
You want to add anything, Tom?
No, I think that here Jim agrees with us, and therefore he's very wise.
So all of these cases, these cert petitions we've just talked about, are due to be considered at the September 24th conference, which
No.
is... Oh, no?
But they're due to be considered soon.
Oh, okay. I thought they were all on that conference. So soon, very soon. But there are even cases bubbling up that people have their eyes on where there are no cert petitions have been filed. Aaron's got his eye on one.
Yeah, the Federal Circuit had an en banc decision in two cases on August 31st. And so it's obviously too soon to say whether anyone will file for cert in those cases. But it involved a question of what's known as divided infringement, which is an issue that comes up essentially only in method claims. And what happens is you have a method which says, my method is to perform step A, B, C, and D. And the accused performs either the accused performs steps A, B, and C, and then tells a customer, here's how you perform step D, or the defendant tells customer A, the first customer, you perform step A and B, and your client can then perform step C and D. So that there's, the method is not performed by any single person, but it is, all of the steps of the method are carried out by someone, presumably with some sort of instruction from one accused infringer. And this is a problem that had led to a decision in the Federal Circuit called BMC in 2007, in which the court said, if you don't have one person who's carrying out all the steps of the method claim, or if you don't carry out all the steps of the method claim, you don't have direct infringement. And so if you don't have somebody carrying out all those steps, either himself or through essentially through an agent or a contract, by controlling somebody through a contract, you don't have direct infringement. And if you don't have direct infringement, then you can't have indirect infringement either. That doctrine got further solidified in the Federal Circuit over the next couple of years, and the two cases that went up to the Federal Circuit involved applications of that doctrine in the two circumstances that I talked about, one in which the defendant carried out some of the steps, and then a customer of the defendant, so not an agent or someone subject to the defendant's control, carried out the last step. In the other, it was the defendant provided software under which all of the steps were carried out by the person buying the software and their patients. It was for medical software. And in what's probably a somewhat surprising decision, the Federal Circuit held that although it's quite right that you can't have direct infringement unless all of the steps of the method are carried out, and so you can't have, I should say, you can't have a direct infringer unless all the some accused infringer carries out all the steps of the method. You can have infringement for purposes of 271B, indirect induced infringement, if all of the steps are carried out, even if there is no direct infringer. So you can have an infringement, and you can have an inducer of infringement, even though there is no direct infringement, because no single accused infringer is carrying out all the steps of the method. And so that decision is very fresh, and because the court divided pretty sharply, there were 6 votes for that holding. It was a per curiam decision. There were 4 votes saying, we've never, this is new territory. We've never said that you can have indirect infringement if you can't have direct infringement. And then Judge Newman, as is not entirely unknown, had her own view, which was that direct infringement ought to be interpreted in a more liberal way to provide for this direct infringement. Anyway, I talked too long about the case, but it's one that I think is a potential cert petition to watch down the road.
Well, we have a few minutes left for questions from the audience. Is there a microphone? Yes. Oh, there's a question right up here in the front. No questions? Everybody's waiting to get to the reception? Mm-hmm. Oh, there we go.
Hi. So how much do you expect patent exhaustion to play a role in the first sale doctrine case involving copyright?
Not at all.
Statutory.
Yeah, I mean, it's funny. In Costco versus Omega, I wrote a brief for a different client, basically talking all about patent exhaustion, and it didn't come up at the argument. It didn't appear to be a real focus of the court's attention. I think they look at this first in light of Quality King, and Quality King's analysis is really purely a statutory one, and as Aaron said, it could be characterized by some as wooden. It's not one that really delved deeply into underlying policies. So I tend not, I don't think that the patent exhaustion necessarily, the development of patent exhaustion doctrine will track the result in this case.
If I could just comment on the case that Aaron was mentioning. There's a statutory definition of patent infringement that says in substance, whoever without authority makes, uses, offers for sale, or sells. And that word uses is one that you would think you know what it means to use something until you come up with the kind of scenario that is at issue in the Akamai case. And in fact, this problem is not restricted to patents whose subject matter is characterized in method form. There can be, and often are, there was a case decided last year called Centillion, I guess it was earlier this year, in which you had a distributed system. And this was an old patent before we had the internet and before we had high-speed transmissions, and it basically was a patent in which the system divided the computing power between one location, which did a lot of pre-processing of the data, and then the pre-processed data was distributed to the customer, and he had an archaic little weak PC that would finish it off and prepare his telephone usage reports locally. And so the patent was written as describing this kind of distributed system and what does it mean? Who is using such a system where part of it is owned and controlled by party A and another part of it is owned and controlled by party B? And that case came up in what I viewed as an extreme situation that just shows you how literal infringement doctrine is a capacious one. This patent, which describes something that had been made, obviously, ages ago, was asserted against one of the Bell operating companies and was said to be infringed when somebody signed up for cell phone service and elected to receive electronic billing. That person was using the system because the very act of enrolling for the service resulted in the mobile phone carrier operating its computer, which the user had no knowledge of, no control over, knew nothing whatever about. But nevertheless, signing up for electronic billing resulted in the carrier operating its system to generate the electronic bill that then was received down into the user's PC and processed locally. And the issue in that case was, does the verb uses describe the relationship between the consumer who signed up for electronic billing and that computer system 1,000 miles away that he has no idea existed but is called into action when he avails himself of the electronic billing service. And prior to the BlackBerry case, in which, in a strategic concession I don't really understand, the persons representing research in motion in the district court conceded that when somebody with a BlackBerry presses the button, that person is using the wireless tower 1,000 miles away that comprises part of the system that was part of the BlackBerry system. But it's that is an issue that is underlying the Akamai case, it is underlying the Centillion case, and it's surprising you have to go back practically to the 1820s to find a Supreme Court case that actually is dead on this question of what legal or physical relationship must exist between an individual and activity that constitutes the individual using the apparatus.
I think we have time for one more question. Dave.
So I have kind of a general question. It seems like the Supreme Court might approach patent cases and copyright cases quite differently, even though they're both statutes are authorized by the same provision of the Constitution. So just looking at the recent copyright cases, including Golan, they don't seem extremely concerned about overbreadth in copyright law, while the last group of patent cases generally have gone, against the patentee or showing more of a concern that the scope of patents and patent law is too broad. And I'm just curious in your thoughts on that. Do you see that? Do you think that it's something about patents versus copyrights, the federal circuit versus regional circuits, just the cases that came in?
I mean, I'm not sure that the generalization is completely accurate as to patent law. I mean, I look at the Microsoft versus I4I case as kind of pointing in a different direction that strongly embraces quite strong patent rights in spite of acknowledged deficiencies in the PTO process. One observation I would make is that it is interesting that so many patent cases in the Supreme Court are decided 9-0. Even though they can appear quite controversial at argument. I don't know why that might be, but it's just an observation. I think the copyright cases in general are more approachable to the court than sometimes the patent issues are. So that might suggest that people get more of the justices get more engaged with it and are more likely to offer dissenting opinions or dissenting viewpoints.
I mean, I guess I'm a little more inclined to agree with you. I do think that some of the justices, and it's very hard, obviously, to say anything about the court as a whole. They have very different views on these questions, but certainly some of them have, in my opinion, embraced the notions that there are too many patents that inhibit too much innovation and there are too many trolls. And also that the Federal Circuit has adopted too many categorical rules that are inflexible. And that just doesn't tend to be, I don't think they view the copyright as having the same implications as a patent right for technological innovation. And so it's less of a problem. And they don't do as much in copyright. And they don't do as much that has, in my opinion, as much big picture significance as they do in patents. And they seem to be warming to patents in a way that I don't see them taking a lot of copyright cases. Copyright has so many more kind of common law-ish foundations, I think.
There hasn't been the same lower court development of copyright law that there has been with the Federal Circuit and patent law. The Federal Circuit's first 25 years moved the lines aggressively in a single direction. So there was a lot more for the Supreme Court to deconstruct in patent law, whereas in copyright law you didn't have that shift. And I think that therefore there's been less call for the Supreme Court to intervene in copyright law. These cases like Eldred and so on, they all arise from statutory developments, not lower court conflicts.
Well, I'd like to thank all of our panelists and invite everybody to the reception outside the auditorium.